thank you everyone for joining us today. And I'm going to go ahead and mute my mic and turn it over to Matt. And then Carolyn's going to be monitoring. Thanks everyone for joining us.
Great. Well, thank you, Jody, so much for the introduction, and thank you everybody for joining today. You know, I'm delighted for the opportunity to present. First of all, I apologize. It's dark in my office. I nonetheless wanted to give a webcam view because I do think it does help to put a face to the name. But I am going to stop sharing my webcam because it does seem a little creepy to be here in the dark. So, but nonetheless, I appreciate everybody joining today to discuss, you know, one of the issues that I think is really important for federal government contractors and is often overlooked. You know, as we see federal contracting opportunities become more and more consolidated and more competitive, one of the things that I do in my practice is I work with my clients and prospective clients to say, how can we shape competitions in those ways, or shape competitiveness to win a particular award? And a lot of the time we're talking about mentor proteges and joint ventures and teaming relationships and developing past performance and that type of thing. But there's another, I think, often overlooked way to help shape a competition, and that is to understand and help set the ground rules. And we'll talk today about a few of the most common ways that your business might be able to do that, and hopefully by shaping some of those ground rules or helping to set some of those ground rules, you'd be more able to steer the competition to one that you'd have a better chance of winning. So I am Matthew Schoonover. I'm the managing member of Schoonover and Moriarty. We are a law firm located just outside of Kansas City in Kansas that works exclusively with federal government contractors. And in that practice, we will work with folks through SBA compliance and FAR compliance issues. We'll work with them on socioeconomic concerns, but we'll also work with them through the bid protest, size protest, status protest process, all of those type of things. And really, as I mentioned, one of the things that I enjoy doing the most is working with clients to help them shape their strategic goals and how to best meet them through the federal government contracting sphere. And although I am an attorney, please don't take what we discuss here today to be legal advice. That is my disclaimer. Of course, a lot of the issues that we'll talk about are fairly nuanced when the rubber hits the road. And so if you have any specific questions, it's best to speak with a local or with a government contracts attorney or your local PTAC. And I'm delighted, by the way, that you have connected with your PTAC, because that is really the best way I know of for small businesses to really get a leg up in federal government contracting. I know Jody didn't want to take too much time, but from my end, PTACs are an absolutely invaluable resource. I refer my clients and prospective clients to them all the time, and I think certainly up in Alaska, you all have one of the best. So I'm delighted that you've joined today, not only because it gives us a chance to talk about that, but more broadly, it means that you've connected with Carolyn and her team. So let's talk a little bit about today's presentation. And as I mentioned, the goal here is hopefully to learn of ways that you can shape a competition. And I think it's best to break it down into three parts. And first, you know, I think maybe one of the overlooked aspects of shaping a competition is actually understanding what the solicitation requires. That sounds silly, but trust me, a lot of times folks bid on opportunities without really knowing everything that is required of them. And I cannot stress how important it is to really know what the solicitation says before you bid on it. We'll also talk about NAICS code appeals and then bid protests and how they might help you shape a competition to allow yourself a better chance at receiving an award. Before we dive into the meat though, I did just want to give a quick plug. Our firm runs govconbrief.com, which is a blog that discusses all of these different topics as they relate to federal government contracting. We focus our posts to be digestible to small businesses, to provide them the information that they need to know, and we try and write on a variety of topics. And we really want GovCon Brief to be a resource for small businesses in the contracting community. So if you haven't checked out govconbrief.com yet, I would certainly encourage you to do so. Also connect with the firm on LinkedIn, because we do plug a lot of this content on LinkedIn as well. So let's talk about actually understanding the solicitation. And this is, as I mentioned, I think a tremendously overlooked aspect to actually taking and shaping that competition. You need to know before you bid on a job what is required for you to do. And again, that sounds elementary, and in some ways it is, but you'd be surprised how often folks don't actually take the time to carefully review the solicitation. Yes, you're going to review the solicitation to know, here's generally what I have to do. Here's when the agency wants me to start work, and here's how they're going to evaluate my proposal. That type of stuff, of course, you're going to take a look at. But it's also important to know who your competitive pool is there. Is this a set-aside? Is it a set-aside for socioeconomic small businesses? If so, do you qualify under that set-aside? Is there an argument to maybe bring it over to a different set-aside? What is the NAICS code that is assigned to that procurement? And what does that NAICS code mean? Is that the appropriate NAICS code for the contracting officer to actually have assigned to this procurement? Because if not, if there's a different NAICS code that is more closely corresponded to the overall solicitation, then appealing that NAICS code, which we'll talk about, might change that competitive pool. Are the solicitation's requirements overly restrictive of competition? That is, are they geared towards one particular product or one particular contractor? Are they written in a way that limits the competitive pool and might be unreasonable? Because that could be something that could be worth protesting. As I mentioned, you're going to look to understand what the scope of work is, but you also need to review what FAR and contractual provisions apply. Are there any errors and ambiguities in that solicitation? Is one provision contrary to another provision in the solicitation? If so, that might affect your ability to actually bid on the contract. And you need to consider whether that's worth raising or challenging in some way. What is your deadline for bidding on this proposal? Sometimes those are too fast. So, and in general, I can say in general, the FAR contemplates that offerors will get at least 30 days in most contexts to respond to a solicitation. 30 days is not a long time, but sometimes it's even quicker than that. And instances where a deadline for proposals might be right away, then that could be indicative of maybe competition is being steered towards one company over another. Consider if there are any differences from the incumbent contract, particularly if you are the incumbent contractor. You know, one of the things that you want to be careful of in that situation is really resting on your incumbent contractor status. And we see this a lot in the bid protest context, where maybe an incumbent contractor loses out on the award and then ends up filing a protest that essentially says, hey, agency, I know what it is you need because I'm the incumbent. And in a lot of ways, they rest on their incumbent status. It is great to be an incumbent contractor. Certainly it gives you an in and it gives you a leg up. But what you need to be careful about is making sure that you don't just rest on that status and assume you know what the agency wants and how it wants that good or that service to be provided. Understand that scope. Know if there are any changes to it that are going to affect the way you bid. If it's a task order, keep in mind too that if that task order exceeds the scope of the underlying contract, that could be problematic as well. And you might have the ability to say, well, wait a second, this task order, it goes far beyond what the underlying IDIQ contract says and is improper for the agency to issue this. Instead, they need to recompete this work. And that could be a possibility for you as well. I encourage contractors to ask questions as part of this process, as part of the solicitation process. You really need to review it carefully and think of all of the things in the in the solicitation that are unclear, that are ambiguous, that maybe aren't well defined, or that otherwise might help you bid on the procurement. And in fact, the FAR encourages the government to communicate with offerors about the requirements so that they understand what it is that the government is looking for. Questions are a good thing under the acquisition process because it helps the agency to explain what it wants, which ensures that the agency is actually going to get what it wants, but it also helps make sure that it is receiving the most competitive bids possible. And oftentimes there's an official Q&A process where offerors are able to ask questions and the contracting officer will answer them. And then those answers get incorporated into a revised or an amended solicitation. So you want to make sure that you are asking questions about the solicitation, because odds are your competitors probably are. And those questions might encourage the agency or spur the agency to make changes to the solicitation. Take full advantage of the Q&A process. Please, please, please remember to do that. And questions, really go a long way in helping to, correct and to clarify the scope of this procurement. You can ask questions to ensure that certain FAR provisions or documents are included in the solicitation. For example, one of the big things that we see are missing wage determinations. If the Service Contract Act applies, you want to make sure that you're using the most up-to-date wage determinations. And if there are any special wage determinations or findings, you're going to want to know those. So make sure that you're asking those questions. Also, if you're banking on the interpretation of a particular term, you want to make sure that the government is itself locked into that interpretation. I'll give you an example. The FAR says that contracting officers may, but don't necessarily have to, consider past performance examples of major subcontractors. Sometimes you receive a solicitation and it's clear that subcontractor past performance will be considered. Otherwise, or sometimes though, it's not so clear. Maybe they say offeror, and earlier in the procurement, they define offeror to just mean the prime contractor. In that case, there could be some ambiguity as to whether the solicitation actually allows you to submit the past performance of a subcontractor. So I think it's helpful in that case to say, hey, government, we wanted to confirm that we can submit the past performance of a subcontractor. Getting them to lock in their interpretation of whether or not you can do that is certainly appropriate and will help you. And by the way, if you were banking on submitting that experience or that past performance as part of your solicitation, or excuse me, as part of your proposal, it's best to know at the outset whether you would actually get credit for doing that. And then finally, you can flesh out any proposal requirements. We see this a lot as to, hey, confirm that the cover page is not included in the overall page count. Again, sometimes that's not clear, but if you're running up against a page count, it's certainly good to know. You want to make sure that you're asking good questions, though. A lot of times we see questions that really aren't clear themselves. You want your question to be short, in my opinion, and pretty precisely worded. If you can, use the actual language in the solicitation or cite to the page numbers or the provisions, the paragraphs that you're actually talking about. So that way the contracting officer knows and can answer the question based on that information. Only one topic per question. You don't want a multiple or a compound question, because if they only answer part of it, it might not be the part that you really need an answer to. Sometimes sub questions are appropriate there, you know, 1A, 1B, 1C, and can help provide answers to those. Not only that, I think asking good questions, and this is very important, helps the government understand how it is you are seeing the proposal, or excuse me, the solicitation as a potential contractor. You want to know, or you want them to know, hey, here's what we're thinking for this opportunity. Have you thought about this? These questions can be a give and take, where maybe the contracting officer says, you know what, we didn't think about it from that perspective. We just wanted you to provide X service, but we didn't think about all of the ramifications associated with that. So we'll revise it to include some of those considerations. Suggest easy solutions to the extent you identify a problem in the solicitation. You know, you can help the government get there to get to the answer that you want. You know, particularly if you identify an ambiguity or an inconsistency, you know, you can point that out in a question and then say, you know, we interpret it to mean this. Can you confirm that's your understanding? And you can help the government get there. You can even be more direct and say, you know, would the government revise it to do X for the benefit of Y? You know, that's a really good way to get the government to hopefully adopt what it is you're wanting. Now, I will say, a lot of times, or sometimes, you might get a response back to your questions that says, please see the solicitation, or you know, see this sentence in the solicitation, or the government intends to view the solicitation as it's written. Something that is very, very unhelpful and frustrating. And unfortunately, you can't do a lot about that. You might ask the same question again from the government, but sometimes the government is just not as helpful in their answers as you might want them to be. But don't view that as a reason to not ask questions in the first place. We'll talk a little bit later about this, but if the solicitation is unclear, if the solicitation is vague, if the solicitation is overly restrictive of competition, or is just wacky for some other reason, that's a legal term. If it's just wacky for some other reason, you need to get that addressed early on, because otherwise those ground rules are set, and it's kind of like, you know, speak now or forever hold your peace type of deal. So you want to make sure that any questions about the solicitation are answered before you submit your bid. Again, I think that shaping that competition starts with knowing what is in the solicitation. It is very, as I said earlier, elementary to say, well, you need to know what's in it. Yes, that is true. And I can, there have been several instances where I've talked to clients and prospective clients that didn't do some of these things and ended up wishing that they would have. So certainly take the time to review the solicitation, to consider any potential changes or issues that you identify, and ask the government at the outset. Now, one of the things that I mentioned that will help shape the competition, or that you should be looking for in your initial review, is what is the NAICS code that's assigned to the solicitation. And just by way of background, a NAICS code, or a North American Industry Classification System code, is a 6-digit code. It's a numeric code that is assigned by the contracting officer that best describes the principal purpose of the solicitation. NAICS codes are developed, or they're assigned by the Census Bureau for each industry in the American economy, and they generally fall under services NAICS codes or manufacturing and supply-based NAICS codes. And they can, they run the gamut. When I say every industry in the American economy, I mean every industry. There's NAICS codes for dog and cat food manufacturing, for paper milling, for, there's Office of Lawyers as a NAICS code. And odds are, no matter what you sell, it will fit into one of those NAICS codes. Then as the contracting officer is putting the procurement together, that CO is obligated, as I mentioned, to assign the NAICS code that most closely corresponds to the solicitation. Why does the NAICS code matter for a solicitation though? Well, here's the rub. Each NAICS code is assigned a size standard by the SBA. For services NAICS codes, those are receipts-based NAICS codes, size standards, expressed in the term of dollars. For manufacturing or supply-based NAICS codes, they're numbers of employees. And in order to qualify as a small business for that solicitation, your size has to fall under the size standard that is assigned to the solicitation's NAICS codes. So in other words, that NAICS code is going to set the limit on who can participate in the event it is a small business set-aside contract, or a contract that is set aside under any of the other socioeconomic provisions. So why would you file a NAICS code appeal? Why does it matter? Well, because each NAICS code has a size standard, and because that size standards determines who can submit a bid under small business set-aside contracts, challenging the NAICS code, appealing the NAICS code, if you are successful, may change the competitive pool of the procurement. For example, let's say that you have that your business is too large under that size standard. If you appeal that NAICS code and say, hey, rather than this code, a different code should apply, and that code carries a larger size standard under which you would qualify as a small business, and if your appeal is successful, you've just made yourself eligible for that procurement from a small business standard. And so you've helped shape that competition to make it so you can bid. Now, conversely, what if you're a small business? What if you're, say I run a business that is that has $12 million in annual revenues, or in average annual receipts, and the contracting officer is assigned a NAICS code that carries a $40.5 million size standard. I might appeal that NAICS code if I can identify a different NAICS code that most closely corresponds and say has a size standard of only $16.5 million, because then I've limited the pool of other businesses against which I will compete. I'm no longer competing against those larger small businesses. I've limited the size of businesses that can participate. So this is a more specific example here. We've got a solicitation assigned NAICS code 541310, which is an architectural services NAICS code, which carries an $8 million size standard. The solicitation at issue, however, demands significant engineering services. And we see this a lot with architectural engineering contracts. Where is that bound? If you have a firm, an engineering firm that has $10 million in average annual receipts, you might not be eligible, or you would not be eligible on this procurement from a small business standpoint. But if you were to appeal that NAICS code and get it changed to 541330, which carries a $16.5 million size standard, you would be eligible. Again, conversely, If we've got a janitorial services contract or solicitation assigned 561210 for facility support services, that carries a $41.5 million size standard. There's not a lot of janitorial companies that I represent or that I'm aware of that have $41.5 million as their average receipts. Instead, they're usually a lot smaller, and maybe your firm, your janitorial company, your receipts are only $12.5 million. Changing that NAICS code to 561720, which has a $19.5 million size standard, again, has limited that pool of potential competitors. So it's very important to think about this at the outset. Who are my competitors and how might I change that? Let's say you do decide to appeal a NAICS code. How do you do it? Well, you file an appeal with the SBA's Office of Hearings and Appeals. Those appeals must be filed. This is a very, very, very fast deadline. You have to file a NAICS code appeal within 10 days after the solicitation is issued. There's a little bit of wiggle room there. If the contracting officer issues an amendment that affects the NAICS code, then that 10-day deadline triggers at that point. But this is why I say at the outset, once you're looking at solicitations, you need to be looking at it and thinking, how can I shape this competition? At least for a NAICS code appeal, you have to file that super early. So think about that right away. And there is no required format when you're filing a NAICS code appeal, in my experience, but you do have to include certain items in the appeal. It does need to be in writing and filed with the SBA's Office of Hearings and Appeals, and you do need to include analysis and arguments as to why the specific NAICS code that was chosen is incorrect, is clearly erroneous. I recently blogged on govconbrief.com where a NAICS code appellant lost their appeal because they didn't really articulate why the chosen NAICS code was not appropriate. That is the first step with a NAICS code appeal. Explain why the NAICS code that is assigned does not work for the solicitation. In doing so, you generally need to cite to the solicitation to identify its key requirements and to explain why the primary purpose of the solicitation does not align with that NAICS code. The SBA Office of Hearings and Appeals is going to decide the NAICS code appeal or sustain the NAICS code appeal only if the appellant can show that a clear error of fact or law was made. That is, if the OHA believes that a mistake was made in assigning the NAICS code. Let me be clear though. The OHA isn't going to sustain a protest or sustain a NAICS code appeal, I should say, simply because it thinks that a different code might have been better. Contracting officers get some discretion to say, I believe this NAICS code is the most appropriate for this solicitation. And just because there's another NAICS code that also might have been appropriate does not mean the chosen NAICS code was incorrect. So that is important to keep in mind as you are considering a NAICS code appeal. Again, you have to show that the chosen NAICS code is based on a clear error of fact or law, because otherwise the OHA is probably going to defer to the contracting officer's decision. There is no requirement under the regulation, or there is no statement that there is only one possible NAICS code and that the contracting officer has to pick the perfect NAICS code. No, again, the standard is they have to pick the NAICS code that best describes the solicitation's purpose, and there is some wiggle room in that decision making. What happens? Well, if the OHA grants an appeal, that is, if it agrees with the appellant and says that the chosen NAICS code is not correct, then it requires the contracting officer to amend the solicitation. Sometimes, and this has happened to me, where we have filed a NAICS code appeal on behalf of a client, and we said, hey, OHA, we think that this chosen NAICS code was wrong, and instead we think that it should be this other NAICS code. The OHA came back and said, you're right, the chosen NAICS code is wrong, but the one that you think should apply, I don't think should apply, and instead I think this third NAICS code should apply. So it's this goofy situation where sometimes even when you win, you might not fully win, but nonetheless, if the OHA believes that a different NAICS code out there best meets the solicitation's primary purpose, the CO will be ordered to amend that solicitation to reflect that new NAICS code. And that happens even if they decide that that third NAICS code is more appropriate. This new NAICS code, whatever they decide, generally will apply to future procurements for the same goods or service. Now, as I mentioned at the outset, sometimes solicitations change, so any change in the scope of work could mean that any subsequent NAICS code would change for future procurements. But if this is something that you bid on a lot, or that you anticipate bidding on this type of work on a lot, and you think the contracting officer might have gotten the NAICS code wrong, this means, this provision means that maybe a NAICS code appeal will help shape not only this competition, but future competitions as well. And of course, another option is just that the OHA denies the appeal. And in that case, you still might be eligible to bid on the procurement, obviously, if your size falls under that associated size standard. But in some cases, if the OHA denies the appeal and your business remains a large business, then it's best to start looking at other ways to participate in the procurement, even outside of the prime contractor context. You can joint venture, maybe you can issue or enter into prime and subcontract relationships. But if the OHA denies your appeal and you're not eligible from a size standpoint, then unfortunately you wouldn't be eligible as a prime contractor. So those are NAICS code appeals in a nutshell. And they are, again, underutilized when it comes to shaping the procurement. NAICS code appeals can be a powerful tool for doing that because they really might limit the competitive range, or excuse me, the competitive pool of offerors that are able to bid. So certainly, if you're thinking about a solicitation out there, think early about, is this the correct NAICS code for this procurement? And if not, or if it's arguable, does an appeal make sense? But now let's talk about bid protests and how your business might actually challenge the solicitation's terms. And this can be another huge way to shape the competition. What is a bid protest? I'm a bid protest attorney, and in my experience, not a lot of contractors want to talk about bid protests, but they are an important part of the acquisition process. And I think that proper pre-bid or pre-award protests in particular are really vital for contractors. A bid protest is essentially a challenge to an agency's procurement-related decision. Oftentimes, there are two types of protests, and I think oftentimes when folks think of bid protests, they think of the post-award variety. That is, the agency has made an award or made some type of affirmative evaluation decision, and an offeror is challenging that. It lost the competition to a competitor, and now it is filing a bid protest saying that the evaluation and award was unreasonable. That, I think, is what most people think of when they think of a bid protest. But just as important, and in fact even more important in some contexts, is what I call a pre-bid or a pre-award protest. And that is a challenge to the solicitation's terms. You can actually say, as part of a protest, hey, this provision is unreasonable, this provision violates some procurement law or statute, it's unduly restrictive of competition, we think that it should be changed. Who considers a protest? Well, there's generally 3 places that you can take a protest, whether it's pre-bid or post-award. You can take it at the agency. You can go directly to the agency. You can go to the Government Accountability Office or to the United States Court of Federal Claims. And when you're looking at the screen there, it's important to keep in mind that you can keep going, that if you start at an agency level protest, you can go to the Government Accountability Office, and then after GAO, you can go to the Court of Federal Claims. You can always go down on that list. You can keep going down. You cannot, however, go back up. So if you file a GAO protest, know that you can't then go to the agency. Similarly, if you file a COFC protest, you can't then go to GAO. So think about that as you're considering acquisition strategy. A pre-award protest, again, is a challenge to the solicitation's terms. You're arguing that there is something wrong, something that needs to be corrected in the actual solicitation, something that is affecting your ability to bid. This is not a NAICS code appeal. You do not file NAICS code appeals as a bid protest. Again, those are considered under the SBA in their separate jurisdiction. You can, however, as part of a solicitation, say this set-aside designation is incorrect. So say, for example, you're going to bid on work, you run an SDVOSB, a service disabled veteran-owned small business, who wants to do janitorial work at a VA healthcare facility in Alaska. And the VA has issued this procurement, but they've done so under a small business set-aside. And you say, well, wait a second. The VA has a special obligation to service disabled veteran-owned small businesses, and there's the VA regulations in the Kingdomware decision. I think this should be set aside for SDVOSBs. And I would say, if that's your argument, that's a pre-award protest. You need to file that set-aside designation or challenge that incorrect set-aside designation as part of a pre-award protest. These type of protests have to be filed before the deadline to submit proposals. Please keep that in mind. Once that deadline passes, those provisions are locked in. Those are the ground rules, and you cannot then, you cannot after the fact complain that you know, hey, there was an ambiguity or the set-aside designation was improper, it was unduly restrictive of competition. Once that deadline passes, those provisions are locked in, and that's how solicitations, or excuse me, proposals are going to be evaluated. So let's talk a little bit about agency level protests. I'll be completely candid. I don't like agency level protests a lot. And we'll talk about why, but essentially what an agency level protest is a means by which the parties can try and resolve a dispute before going to another forum. There is no automatic stay of award or anything like that. There's no protective orders, but you will get your decision quick, within 35 days in most cases. Sometimes the agency might take longer, but essentially what you'll do is file, you know, just, it can be really quick and easy, but you know, a letter or a writing to the contracting officer that says, we think this provision should be changed and here's why. And the contracting officer will consider it and issue a yes, no, maybe so decision within 35 days. And that's pretty much the process. You know, the FAR says that these type of protests are supposed to build confidence in the acquisition system. I don't tend to think that that's the case. It is true that they are less expensive and generally quicker than GAO and certainly Court of Federal Claims decisions. They also are more private than filing at GAO or the Court of Federal Claims, because there's no public decision. Instead, only the contracting officer or only the protester will get the decision. That said, if it's a pre-award protest and you're asking for the solicitation to be changed in some way and the contracting officer agrees with you, then of course, you know, an updated solicitation will be issued. So, and again, when you file these, the agency is under no obligation to necessarily stop the acquisition, to say, okay, we won't issue an award, or we won't issue, or we won't allow the awarded contractor to proceed. They can continue the acquisition while an agency level protest is pending. Here's why I don't like agency level protests though, because you're essentially asking the agency to change its mind. And oftentimes the agency has just made up its mind, and you're going to them and saying, hey, I think you were wrong. I want you to do this instead. And in my experience, it just doesn't tend to be as effective as otherwise. Now, in the pre-award context, where you identify an obvious flaw in the solicitation or something like that, it might be more acceptable or more easier to do at that point. But still, I think you just run into some institutional inertia with trying to get the agency to change their mind about something. You don't get access to any of the underlying documents to argue your case. You're just basically arguing it on the information that you know. You present that to the agency, and then one day, a month or so later, the agency will issue its decision to you. So it's not like you get to stress test arguments with access to the underlying record. And again, as I mentioned, there is no automatic stay as you would get, say, at a GAO protest. So all the while this protest is pending, in theory, the agency could be proceeding with the acquisition. And of course, that minimizes any contractor leverage. So I tend to think that except in limited circumstances, agency level protests probably aren't the way to go. Agency level protests in particular, this is especially true because really when we talk about the procedures for filing an agency level protest, they're pretty similar to actually what looks like a GAO protest. So in my mind, most of the time, it's best to spend that effort rather pursuing an outcome at GAO. Now, who can file a protest? In the pre-award context, you have to be an actual or prospective bidder that's adversely affected by the problem you're talking about. That you're going to bid on the solicitation and you're prejudiced by the impropriety in some way. You're what's called an interested party. Now, this does have to be in writing, but it can be fairly informal. You just have to provide some information as part of your filing. And the meat of it is, what are the legal and factual grounds for your relief? Why are you asking the agency to change or to do something different? And you also, by the way, have to identify what it is you want them to do. Give them, tell them the relief that you want, which can be overlooked. You're going to send them to the contracting officer, and they're going to be reviewed at one level above the contracting officer. Again, though, that process is fairly opaque because it is done entirely in the agency. Now, the outcomes or the possible outcomes for an agency level protest, the agency can always take corrective action. It can always say, yep, we voluntarily agree to take corrective action, or it can enter alternative dispute resolution, ADR, by having some negotiations to maybe go short to maybe meet some middle ground. It can sustain your protest, or it can deny it. And if it denies it, then you can take it to GAO, but you have to do so within 10 days of actual or constructive knowledge of the adverse agency action. So keep that in mind here as well. Unfortunately, the agencies do not publish any information about agency level protests as far as metrics or stats go. So we really don't have any information about the number of agency level protests that are filed or their success rate. GAO protests, on the other hand, are far more common, and I think in my experience, the most common forum that's going to resolve bid protests. The Government Accountability Office is an arm of Congress that has jurisdiction to, among other things, review bid protests and challenges to procurement-related actions. in most cases. Their resolution process is going to be the same for either pre-award or pre-bid protests or post-award protests. And in general, what's going to happen is you'll file a protest. We'll talk about that in a little bit. Then if there are any motions or if the agency takes corrective action, or if it doesn't do that, the agency will file its substantive response, what's called the agency report, within 30 days after the protest is filed. As part of that agency report, it's going to produce all relevant documents relating to the issue at hand. And you know, the good thing about GAO is that if you have counsel that's admitted to a protective order, those counsel can view those documents and really use it to bolster the arguments through comments, which are due 10 days, which is, you know, basically the reply brief, and potentially raise any supplemental protests as well. GAO will issue its decision on a protest within 100 days after filing, and that is a regulatory deadline that GAO always meets. And in fact, I think the only time I'm aware that they didn't meet it was back in like 2012 when the government was shut down, or 2013, and even then they met it for most of those protests. It was just a few that they didn't. So the protest process at GAO, it is not as fast as an agency level protest, but it is still pretty, 100 days is pretty quick in the grand scheme of things. GAO, when it decides a protest, because it's an arm of Congress, it cannot order an executive agency to do anything. So instead, GAO issues recommendations to the agency. We sustain this protest and we recommend that the agency redo the evaluation or something like that. And the agency, for the most part, will follow those recommendations, because if they don't, they have to tell Congress, the agency has to tell Congress why it did not, and nobody wants to be in that position. What are the requirements for a GAO protest? Well, again, you have to be an interested party to file that protest, which means, again, an actual or prospective bidder for a pre-bid protest. You have to, again, provide a writing that details the factual and legal grounds of the protests and the relief that you want, as well as some other information. Always get counsel to apply for a protective order, because, again, that way you make sure that you're going to get those documents. If there are specific documents you want as part of the protest, you certainly ask for them as well. GAO might hold a hearing on a protest, but it probably isn't going to happen. I think in 2020, GAO held hearings in less than 1% of the protests that it considered, and instead, for the rest, it just resolves them on the briefing. You're going to file a protest through GAO's electronic protest docketing system, a lovely system we call EPDS. There is a $350 filing fee, but really it's not too bad. There are also other obligations, and I'm starting to speed up here a little bit to make sure that we get through these things. But if you're going to want to provide a redacted copy of the protest within 1 day to do that. If you have an award that is protested, by the way, make sure to ask the contracting officer for a redacted copy of that protest. Why are you going to file a pre-bid protest? Let's get back to the meat of it. Well, if something's unclear in the solicitation, you need to know what it is the agency actually wants. Sometimes contracting officers, not sometimes, but a lot of times, they're using templates, or they're using something that pops up in their system to work on a solicitation, and not everything is applicable. So if you think there's something in there that is unclear or something, then you need to make sure that you're protesting that. If something is unfair, that is, if they are writing the solicitation, you think in a way that is unfairly advantageous to, say, the incumbent or to a different contractor, that could be a basis for protesting. And if you want to play with the competitive pool a little bit, again, if it's unduly restrictive of competition, or if there's an improper or an incorrect set aside that restricts competition, changing that, protesting that could be a good way to affect that competitive pool. Now, GAO is very helpful that they publish some stats on successful GAO protests. And in 2020, the second most prevalent reason for sustained a protest at GAO was a flawed solicitation. There was something incorrect in the solicitation. It was a pre-award protest that successfully argued that the solicitation should be changed. Maybe there was ambiguous terms, there wasn't enough time to prepare and submit a bid, it was too restrictive, it bundled work improperly, or it was a task order outside of the scope, or the wrong set aside. Those are all ways or all arguments that we have seen be successful at GAO. Keep in mind, though, that there are arguments at GAO that I think are very unlikely to succeed. Those are if you say the contracting officer issued the wrong scope, or the evaluation procedures are wrong, they don't know what they want, or that they're procuring the wrong thing. GAO says that agencies have discretion to determine what they want and how to buy it. If you're also arguing bias, if the government, if it really is biased against you or biased in favor of somebody else, using the word bias is not great in protests. What are the possible outcomes? Corrective action is always one. And I think for pre-bid protests especially, it's easy for an agency to take corrective action to say, okay, we'll fix this issue, or we'll clarify our requirements here. So corrective action, in my experience, tends to be more likely in pre-bid protests than perhaps post-award protests. So certainly keep that in mind as you're thinking about pre-bid issues. Again, ADR is a possibility where GAO will issue a resolution short of a written decision. There's also that sustained possibility where the GAO is going to issue a recommendation. In the context of a pre-bid protest, oftentimes that's to either clarify the requirements or a recommendation to change the terms in some way that's otherwise going to promote competition. And of course, GAO could also deny a protest, but nobody wants to think about that. Finally, the Court of Federal Claims. This is a third possible venue. We're not going to spend a lot of time talking about this because the Court of Federal Claims, it's a lawsuit against the federal government, and it tends to be more expensive and it tends to take a lot longer than GAO protests. But in some cases, it might be appropriate to go to the Court of Federal Claims to ask for their relief. Maybe there's a lot of potential protesters at issue, or the issues are pretty sophisticated. It might be worth going to the Court of Federal Claims. Unlike GAO, you would have to move the court for equitable relief to essentially stay performance. Getting that injunction can be difficult, and you have to have counsel. Now, I think of the Court of Federal Claims, given the expense and the complexity involved, that it's a last resort, really, for protests. I think you've gone to GAO and maybe lost or not gotten the relief you wanted, and now you're going to the Court of Federal Claims to maybe change some things. Contrast to GAO, there's, GAO in 2020 had almost 2,200 cases filed under its bid protest jurisdiction. The Court of Federal Claims, by contrast, had only about 120. So that shows that really it's a little bit of a different process when you go to the Court of Federal Claims. Nonetheless, it is an option for protests, and I think one for certainly in the case of pre-award protests as well. So with that, those are some ways in our practice that we have seen folks be successful in shaping competitions. Again, you want to, at the outset, understand what the solicitation requires. And if you had your druthers, how are you going to change that in a way that's going to make your business more competitive? Maybe it's changing the competitive pool through a NAICS code appeal, limiting the size of business that you'll compete against under the procurement. Or maybe it's changing some of the provisions in the solicitation to make your business more competitive or more attractive to the government in its evaluation. These are very important things to think about as you're bidding on opportunities. And again, the deadline for them is very, very fast. So if you're at all considering them, please certainly don't delay. Make sure that you are protecting your rights. Now, with that, I know it's been kind of a whirlwind hour. We've covered a lot of ground, but I do want to open the floor for some questions if there are any, and to certainly thank Carolyn and Jody and the rest of the Alaska PTAC for their time today and allowing me to join. It's certainly been my pleasure.
Well, thank you, Matt. This is Carolyn with the PTAC, and we do have a couple minutes. If anybody has a question, you can pop it into the question box. And it looks like we have some coming in. So, Matt, here's a question. If we respond to sources thought that has a NAICS code that's not assigned to our profile in SAM, would we automatically be disqualified?
The answer to that is generally no, and perhaps even more frequently than generally. It is a misconception or a misperception. It's a mistaken belief that in order to bid on a particular government solicitation, you have to have the solicitation's NAICS code under your SAM profile. That is not true. There is no requirement under the FAR or any other regulation that I'm aware of that requires you to actually have that solicitation's NAICS code under your SAM profile. And in fact, I think GAO just issued a bid protest decision stating as much. Now, I will say that sometimes, very rarely, but sometimes it does happen, where a contracting officer might say in the solicitation, you have to have this NAICS code under your SAM profile. And in that way, there's kind of two options. First of all, you're going to want to make sure you've reviewed the solicitation carefully to see whether that provision is in there. If it's not, you should be good to go, because again, there's no requirement that I'm aware of. But if a provision requiring that is in there, I think there's really one of two options. First, see if you can amend your SAM profile to get it listed. Second would be maybe consider asking the contracting officer to change that or eliminate that requirement. And then if the contracting officer won't do that, then to challenge that decision through a bid protest, a pre-bid protest, to remove that requirement as unduly restrictive.
Okay, thanks, Matt. And we do have a second question. Can a subcontractor protest a bid?
In general, no. A subcontractor generally does not have standing to challenge, well, certainly to challenge an evaluation or award decision. The question is, can they challenge a bid? By that I mean a solicitation. I don't know if they could challenge a solicitation or not. I think arguably they could as part of a pre-bid protest, but I've not seen it happen before. So I'm hesitant to say yes. And I do think that in general, to have standing, they would have to be that actual prospective bidder. So I think it's going to have to be the prime contractor as I think about it. But that's a very good question. If you are a subcontractor and you see something in the solicitation that you think is unclear, certainly talk to your prime about it and say, hey, we think that this should be challenged, or we should ask a question about this. You know, make sure that you're trying to get your prime to avail themselves of those chances. And if the prime won't do that, then you know, maybe we can talk about options from there. But I do think, and I'm not sure if I mentioned this, but before filing a pre-bid protest, in my mind, it always makes sense to ask the contracting officer questions and maybe to see if you can get that voluntarily changed. Sometimes issues of timing won't allow you to do that, and you've got to file a protest in advance, or without having the opportunity. But if you get the chance, in my experience, a lot of times contracting officers are willing to change those provisions voluntarily.
Okay, good question. So we have time for one more, and if there are others, just for the sake of time for people to be able to stick to their schedules for today, we'll ask one more, and then if you do have others after we end our webinar today, please feel free to email either myself, and I think Matt, you would be also available if people have additional questions after you get to digest a little bit of what was presented today.
Absolutely.
So,
I love fielding questions. My email and phone number are on the slides, so please feel free to use them and to reach out whenever.
Okay, so here's our last question, and then we'll do a wrap up here quickly. Are there circumstances when the government doesn't have to offer an opportunity to submit questions?
I suppose so. I'm not aware of a regulation or something that says, hey, in this context, they don't have to allow questions. If you're unsure, I always say ask the question anyway. There's no harm in my mind that I'm aware of an offeror asking a question, even if there's not necessarily a question and answer period, or if you're outside of the question and answer period. I tend to think if it's a good enough question, the contracting officer will probably want to answer it, because again, they have an interest in making sure that folks understand what it is they want. And so I'm not aware of a situation where they can say, nope, no questions. I suppose they could, but it would be very, very foolish in my mind for them to do so. And if they do, then ask anyway.
All right. Okay, well, we're going to have to wrap things up. Matt, thank you very much for your time today. Just for the folks to know, Matt was volunteering his time today, so we greatly appreciate you having time to spend with us, and also appreciate the information. I thought the presentation was very digestible and didn't go too deep into some of the legalese that sometimes can happen. So
it puts me to sleep.
So just on a final note, again, if you discover you have some additional questions or want some more information on today's topic, please reach out to our PTAC team or to Matt, and we'd be happy to do any kind of follow-up with you. And so with that, Matt, again, thanks. I will say Matt has been a very good friend to the PTACs nationally, and so it was really nice to be able to bring him into the Alaska arena, and would welcome you back anytime.
Well, I'll take you up on that. Absolutely.
All right.
It's always a pleasure to support, and I appreciate everything you and your team do.
All right. Thanks a lot, everybody.